Hi, everyone. I am Washington, D.C. lawyer Frank Carney, and I'd like to talk to you for a few minutes about ERISA long-term disability cases. Now, a lot of people have long-term disability either through a plan that their employer purchased at work, or maybe you've got your own personal plan that you bought on your own. And it's supposed to protect you from any kind of serious illness or injury where you can't work, you can't do your job. It's really income protection. And that's what we're going to talk to you about a little bit today. It's what if you've had a condition or you've got a condition that's getting worse, for example, and you think that you may need to file for long-term disability benefits. How do you do that? How should you protect yourself? What steps should you take? Or maybe you've gotten a letter from the insurance company. You've been on disability insurance, but you've gotten a letter saying your benefits are going to be stopped or terminated. We call that a denial letter. What kind of steps should you take? What should you really be looking out for so you can protect your interest and protect that income? All right. So long-term disability benefits, they provide income if you can't work. Sounds great, doesn't it? Sounds easy. But there's a catch. And anytime you've got insurance companies involved, there's always a catch, right? There's always fine print. We all know that. And these insurance disability policies are insurance products. They're written by and for the insurance company. And who do you think the insurance company is going to favor, right? It's not going to be you. It's going to be the insurance company, of course. First of all, most disability policies, long-term disability policies, are governed by a federal law called ERISA, the Employee Retirement Income Security Act. It was passed by Congress back in 1974. Great intention. It was originally to protect employee pensions. That's great. It soon evolved to encompass all kinds of employee benefits, including long-term disability cases. Now, it's a federal law, and it basically gives disability insurance companies the ability to decide who gets benefits, why they get benefits, whether they get benefits. Gives them a lot of deference, a lot of discretion. So it doesn't really regulate insurance like states do in their different insurance products. Okay, so that's one key component. Now, when we say that insurance companies have the discretion to decide whether you get benefits and for how long, what does that really mean? Well, just like you think. I mean, it means just about anything. As long as they can come up with a reasonable justification, a reason for why they denied or terminated your benefits, then they're going to get the benefit of the doubt. And a federal judge is going to give them the benefit of the doubt, because every ERISA long-term disability appeal that is denied, the next step is to file a federal lawsuit, file a case in federal court. And that's really the number one thing that makes ERISA disability cases so difficult, is that discretionary clause, is the fact that they've got that discretion. Because what that means is, the judge then isn't deciding whether you're disabled or whether you've got a condition that prevents you from working or what kind of work you can do. None of that. He or she is deciding whether the insurance company's determination was reasonable. Did they have reasons? Did they have a basis? So it's not what you would think under that common sense standard of, I'm disabled, I can't work, I've got a terrible condition, and I deserve these benefits. That all can be true, but that's not what the judge in an ERISA case is going to be deciding. And so that's why you really need to think about this differently than any other kind of case, realistically, okay? Because that's a really tough standard. It just gives so much deference to the insurance company, and that insurance company is both making the decision of whether you're going to get benefits, and two, paying the benefits. That's what they're responsible for. Kind of a built-in conflict of interest, right? So how in the world do you fight that? Well, here's 4 basic steps that you can take in just about every ERISA disability case, all right? Number 1, read and analyze your long-term disability policy. Is it governed by ERISA? Most of them are, but the policy will indicate that. How does the policy define disability? How does the policy define your own occupation? How does the policy define the material aspects of your job, of your occupation? What's the term of the benefits that you're entitled to? What percentage are you entitled to? Do you have to apply for Social Security disability? Do they get a credit or an offset if you get some other type of benefits, like state workers' compensation benefits, or benefits from a from a lawsuit in an injury case, or Social Security disability? All of that will be in there in the policy, and a lot of that may govern or should govern the actions that you take. Okay? So after you've read and analyzed and know the policy backwards and forwards, what else do you have to do? Well, second, work with your doctors. Now, we all know doctors are busy and they don't want to fill out forms and they don't want to take up any extra time. Okay? So a lot of times you'll probably have to hire the physician, essentially pay for his or her time at an hourly rate to meet with them, to go over them so that they understand the definition of disability in your specific policy. And so that they can write you a report or gear their records, their reports and letters toward that to help you prove your case. Look, it's not, it's not enough for the doctor just to say that you can't work. He or she has to explain why your condition or injury prevents you from doing those aspects of your job. And he or she's got to back it up. What's the evidence behind that? Incorporating, lab tests or additional testing or imaging or evaluations or other specialists. Kind of all the medical information should go into that to form the basis for the doctor's opinion that you can't do the job because of the injury or illness. And again, paying attention to the definitions in the policy as far as disability, because your doctor may think it's something totally different. They don't teach this stuff in medical school. So you have to educate all the physicians you see, all the healthcare providers, really, in order to maximize your ability to present a successful appeal to the insurance company, because that's who you're appealing to. Number 3, if you've gotten a letter denying benefits already, you got to request and review the insurance company file, the whole thing, okay? So it may be medical records. It may be correspondence and records from medical consultants that they have hired or experts they have hired. It may be vocational information. It may be job analysis forms. It may be a form you filled out 2 years ago you don't even remember. It can be emails and correspondence back and forth. All kinds of things. You want the entire claim file. And it's probably hundreds and hundreds of pages long, depending on how long you were on claim, on how long you were getting benefits. And you've got to be assertive and you've got to be aggressive with the insurance company, because they're going to drag their feet and they're probably not going to give it to you the first time. And they're probably not going to just do the right thing right away. They're going to delay. So you got to really be after them to get that, because that is really key. Once you get those hundreds of pages in your claim file, you got to organize it, analyze it, figure out if there's anything missing or anything doesn't comport with, isn't in accordance with what the policy definitions are or what the policy says. And then you got to add to it, quite candidly. And that's, really number 4, is you got to start working now. If you've got a denial letter, you got to start working now on all the evidence that you're going to want to put into your appeal. And here's why. Because under ERISA, you've got 180 days to appeal, 180 days from the date you get that denial letter. That's not a lot of time, because you don't, depending on what you may need, given your specific condition, it may be a considerable undertaking. So let me give you, a couple of examples of what people generally need or are looking to get in order to make us the strongest appeal possible. Okay, maybe you need a second opinion from another doctor or physician. Maybe you need additional medical testing. Maybe you need a consultation with a specialist who, treats and has written about your condition. Maybe you need vocational analysis to, an expert to undertake to review all of your job duties, your limitations, your restrictions, how they fit, whether you can do those. Maybe you need a functional analysis, a physical or capabilities analysis, which is basically testing to, verify and document the physical limitations that you may have as a result of the injury or illness. And then you use that, you match that up with your actual job duties. And those are just, a few of the things, whatever you need, whether you need all these things or one of them or 12 of them, 12 more. The key is you got to get started now, because you got to get started right away, so you don't miss anything. Okay. So if you've already gotten an ERISA denial letter, then you need to start working. Again, you've only got 180 days, and that appeal is going to the insurance company. What we do is, if you have a denial letter, we will review that letter for you and give you our thoughts as to the next steps that you should consider. Okay, we'll review your denial letter for free, no strings, no strings attached, no obligation, all completely confidential, of course. Okay, and give you our thoughts on it. And then after that, if you're comfortable handling the case on your own and filing your own appeal, great. I mean, that's good luck to you. We think that's difficult, certainly, because of the standards on appeal, because you only get one shot on appeal, because if your appeal is denied and you have to file a lawsuit in federal court, the only thing that the judge is going to be able to look at to decide your case, to decide whether the insurance company was reasonable, most likely, is the administrative record. And what's that? That's the record on appeal. So that's all of the evidence that you're going to add to the appeal and the opinions of your doctors and vocational specialists and and the other experts that you work with and coworkers and all kinds of things that you can put in there to help your appeal. So if you don't want to do that, if you are interested, if you don't think that you can do that on your own successfully, well, certainly, I mean, for the right cases and the right folks, we do offer the ability to review the claim file, get that, review that for you, and of course, analyze, draft, work with you, and file, an appeal on your behalf. Now, again, your claim file, it could be hundreds and hundreds of pages, but that's really where you gotta focus, is on the appeal, because that appeal just it means everything in the case, and so I can't stress that enough. I would say that's where you got to put your focus. So make sure you get everything in there, and you develop all of the evidence that shows that your injury or your illness, your condition, means you cannot do your job. You can't do the specific job duties, and that's critical. Okay, I mean, a lot of people, unfortunately, they think that, or they've been led to believe that, an appeal of an ERISA long-term disability case is just sending in a few forms, and you send in a form and a doctor's report, and the insurance company will just award benefits, or will reverse their decision and grant benefits. Unfortunately, that's not the way it works. So if you have questions about ERISA long-term disability, please reach out to us. Please give us a call. Okay. All we do is represent people who've had serious injuries in different ways. And the reason that we've gone into this business is to try to help people. And so, we'd love the opportunity to try to help you. And I'll tell you that, if you do call us, you will speak with someone who is genuinely nice, genuinely concerned, who will listen to you, and most of all, who will respect you. Because that's a lot of what this is about. You will see, if you've gotten a denial letter, that the undertone of that letter from the insurance company, whether it's, Unum or Reliance or Sedgwick or SunTrust or whoever it is that you're faking, or that you're lying, or that you're malingering, or that you're somehow not truthful. They don't know you. They don't know how hard you have worked to get to where you are, or how you have never asked to be in this position, and what you've sacrificed to get there. And so, the last thing we want to see is to have someone lose everything they've worked for, just because they don't know the rules, basically, or they don't know the standards. They don't know what's expected or what goes into these cases. And quite candidly, how would anyone know that, right? So give us a call, 202-393-3320. And we'd love to hear from you. I just want to thank you for watching. Again, I'm Frank Carney, and thank you.